quite a number of members soon. Honorable Sheikh Imam.
Chair, yeah, I'm joining the Chief Whip's meeting at 10 o'clock. Yeah.
Yes, it does give us a bit of a problem. Advocate Bial, you have your hand up.
Morning, Chair. Morning, honourable members. Chair, I'd like to tender an apology for our acting secretary, Mr. Ramaru. He's with the Minister and the Deputy Minister at their engagement this morning. I'll be here with the Advocate Kritzinger.
Yes, thank
from the
you. Thank you
department.
very much. I was going to apologize for the acting director when we got to that item, but thank you for informing us. Honorable Blanche.
Chairperson, thank you. When we are going to discuss the agenda, there's just something that I want to raise. I will keep it till that stage, Chairperson. Thank you.
Wonderful, Honorable Blanche. You'll be given an opportunity then. Honorable Sheikh Imam, is your hand still up or is it the historical hand? Honorable Sheikh Imam? It seems as if that's a historical hand. Babawa, do we have a quorum?
Good morning, Chair. Yes, we do have a quorum.
Thank you very much, honorable members. The meeting has started. You are all welcome. As you have listened, we have received a number of apologies. We'll be businesslike today so that we can cover the agenda. We can have I'm not going to have a long introductory and opening remarks. Let us get straight to the agenda. And then we have done the apologies, the agenda, the minutes, and then we get into the business of today. Honorable Blanche wanted to comment on the agenda. Let us look at the agenda. We have the consideration of the minutes, the adoption of the committee report. Then we have a further presentation of the ICRC. I'll also ask the department to give their response. And then I'll also ask Nicolette to take us clause by clause through the bill once more. Honorable Blanche, you had your hand up regarding the agenda.
Chairperson, can you hear me?
Yes, I can hear you.
Thank you. Chairperson, I don't have a problem with the agenda as such. I just want to raise something else, and I know that we are not going to be able to spend a lot of time on other things because I know that what we are doing is rather important. Chairperson, we as committee members and the committee itself are receiving a lot of questions, queries, if you like, non-performance from the police. People don't always get the necessary joy, and then they obviously approach the committee and even the members, personally, they address the committee and all the members, name by name. Chairperson, my concern is, and I think we must just decide how are we going to deal with that going forward, because people are complaining now that sometimes they don't even get a response from the committee now. And I don't think we want to, leave that legacy that people, even if they contact the committee, there's still no response. And the question then is, where do they go from there? Chairperson, I think we just need to decide on a process that will be followed to ensure that people are going to get the necessary attention if the police is not performing. Thank you, Chairperson.
Honorable Blanche, we are all in that same boat. Where we have two staff members, we are inundated with questions and we are now having to respond on matters which relate to police stations and police stations in its location. And it then does make it almost impossible and nearly impossible for us to respond to every complaint we receive. And in fact, we should be responding to those complaints.
Recording stopped.
We had those similar challenges with the Central Firearm Registry, where we would receive close to 100 emails a day. We are now receiving complaints, which, as you correctly say, range from matters which arise in communities,
Recording in progress.
Police stations. And what we also found is that initially people thought that they could all rush to the portfolio committee and that they would receive responses from the portfolio committee. It then almost leads to us having to micromanage police, and instead of us doing our oversight work, we are now involved in the day-to-day running of police stations, which does make it very difficult for us to operate and perform our oversight functions. Honorable de Blanche, the Minister, the Deputy Minister, and the National Commissioner are not in the meeting today. Do you accept that we do not deal with this matter in detail today, since we would be basically speaking to the Civilian Secretariat and not to the people we should actually be addressing our concerns to? So could we, for today, not discuss this in detail, but we share your frustration? Even the staff, Nicolette is alone. Dr. Kinnis is no longer with us. She is now our content advisor, but we don't have a researcher. Babalwa is the committee secretary. It's a nightmare for Babalwa. For us to just follow a daily routine, we send the complaints to the SAPS department. I would like to say that Colonel Stein, he really goes out of his way to assist, but the flow of complaints and the barrage of complaints is just become totally out of control. Honorable de Blanche, do you accept that we need the Minister, the Deputy Minister, and the National Commissioner when we raise this matter?
Chairperson, yes. I agree that, obviously we don't have all the people here. And yes, I think we need to discuss that, when these people are back. And maybe we can ask Colonel Stein in the meantime, if you so agree, that he should maybe take up, with his, seniors there in head office on how they suggest we should be tackling this. Because this is now, and I understand that the minister and the deputy, they have their own other thing also to attend to. But Chairperson, then again, today is the third consecutive meeting that our minister is just not here. Really, we need to keep him to account, and he's just not available anymore. So I'm also concerned about that, Chairperson. Thank you.
Thank you, Honorable de Blanche. We'll raise the matter with the Minister. I do understand that with the current situation in our country, the Minister does get called for a number of things. So if there's a conflict between what he is expected to do from the side of the executive, we do have that kind of tension between the responsibilities he has towards the executive, the president, and the committee. We have normally had the deputy minister here, so it does create a bit of a vacuum if both the minister and the deputy minister are not here. Honorable Shembeni.
Thank you, Chair.
Good morning, Honorable Shembeni. My apologies for not greeting you.
Good morning, Chairperson. How are you? Chairperson, yes, I just want to support Honorable de Blanche. And looking at the crisis that we are having now with the SAPS, it's really, really going to be a problem with us. Because remember when I said that I don't want EFF to be part of this failure by the committee to do its oversight or to hold the executive accountable. Because now we are busy with other things, whereas we can see that our country is going down the drain because of the SAPS, that it's too much political, that it's corrupt to the core, and then we are doing nothing. There must come a week from Monday to Friday where we must be busy with the SAPS chair and stop playing, even if it does, and we must have a physical engagement with these people, not on visual platforms. Let everybody be there. The provincial commissioners, the top management of the SAPS, they call it top management, and then the minister and the deputy minister with the civilian secretariat. Sometimes I think they must also be there because they've got a duty also to look into, they've got a mandate to look into this department. It's really, really, really scary. These things that we are getting every day. Now we've got questions that were not going to be answered here today. And things are getting more angrier and angrier. They regard us as useless, Chair, to mention it. That is what they are saying about us, that we are so useless. And then let us stop this thing. And I think we must stop now going beating about the bushes, attending to some other things that I don't say they are not important, but this is a matter of urgency. SAPS, the country is under siege because of this department. If we can get this department right, our country can be 100% right, Chair. It's really, really important. You look at the corruption in all these sectors. If SAPS is not corrupt, these other sectors or departments won't be corrupt because they are corrupt because of the mother of all this department is the SAPS, and it's so corrupt to the core. So let us do something. Let us stop these meetings without that are not fruitful and go straight. Let us, even if we can sit day and night, we get a place where we can sleep, work day and night just to deal with the management of the SAPS and get answers from all those questions that we are having. Those that are implicated also, we must see what is being done. There is a lot. I cannot mention it. It is not the right time. But I need to talk. I've got a lot here that I need to be answered. But I see days are going, people are living as if nothing is happening. No, we can't. We can't. This must come to an end. Let us consider to get a proper day or week, as I'm saying, Monday to Friday or Monday to Monday, we deal with the SAPS management from province to province, and we start from the top. Because there are things that were not answered. The ex-commissioner said those people must apply for their positions. They did not, meaning that it's nothing, it's rubbish. And most important thing, people were given promotions without applications, without being vetted, without being interviewed and everything. Look at what we are today. This is what is happening. They are fighting for positions, corruption, employing their families and all this, promoting their families. Now SAPS is a garden. No, we can't. We can't accept this. Thank you, Chair.
Honorable members, Honorable Shimpeni and De Blanche and all the members of the committee, we have heard the request for a physical meeting and for the strategic meeting, and I cannot agree with you more. We have all agreed that that is required. Nicolette will come back to us soonest with a date. It is not easy to get a date. So we have agreed on a physical meeting. We have agreed that it must be more than one day. And if you can give us time, we will come back to you on the details. Honorable Shembeni, you do not need to think that I have not heard you. I listened to all members, irrespective of the political parties, but on this matter of us meeting physically and have in detail discussions with SAPS, we are all united as a committee, irrespective of our political parties. Members, could I accept that we all agree on this? Honorable members? We all agreed on a physical meeting and we all agreed on more than one day with the senior managers. Are we in agreement?
Yes, Chairperson.
Okay. Okay.
Agreed? Thank you. Honorable members, that takes us now to the minutes. I'm not going to go through the minutes page by page because what we approving today would be corrections to the minutes and additions to the minutes. Could I then put before you the minutes of the 24th of August? You had the minutes well in advance. Do I have a proposal for the adoption of the changes for the 24th of August? The revised minutes? Do I have a proposal for adoption? There were matters we had to correct. Honorable members? Honorable Shaky Mum, could you mute your mic, please? Honorable Shaky Mum, mute mic. Members, do we have a proposal for adoption?
Good morning, Chair.
Good morning, Honorable Peacock.
I propose for the adoption, Chair.
Honorable Peacock proposes for adoption. Do we have a seconder?
I second, Chair.
We have a seconder, Honorable Siabi. Welcome, Whoop. We hope you will feel better soon. Get well. Could we have the next set of minutes, the 31st of August? 31st of August. Do we have a proposal? These are also edited and corrected. 31st of August, do we have a proposal for adoption?
I propose for the adoption, Chair. Peacock.
Honorable Peacock proposes adoption. Do we have a seconder?
I second the Chairperson.
Seconded. Thank you very much. The 7th of September. The 7th of September.
I propose, Chair.
Proposal for adoption. Honorable Peacock. Do we have a seconder?
Second that, Chair.
We have a seconder. Thank you very much. That was the 7th of September. Could we go to the 14th of September now? The minutes have been edited and we have all received it. We have corrected the minutes now. Could we consider the minutes for adoption, please? Proposed. Do we have someone to propose adoption? Could we
Chair.
propose adoption? Whoop. Do we have a seconder?
Peacock seconds.
Peacock seconds. Thank you very much. That takes us to the minutes of the 21st. Honorable members, do you have any additions to the 21st? We have scrutinized it. The committee deliberations are there. The responses by the civilian secretariat is there. The set of minutes is very important for our records when we do prepare our reports. Do I have a proposal for adoption of these minutes?
Sheikh Imam, Chair.
Sheikh Imam proposes adoption. Do we have a seconder?
Malekwa seconding, Chairperson. Thank you.
Thank you very much. Honorable members, that takes us now to the next item on the agenda. We are done with the minutes. We are now going to deal with the report of the Portfolio Committee on Police on the addendum to the annual performance plan of the Department of Police. We completed this. The report, you have received the report. The report is before you. We'll go through it page by page. Honorable members, you have page 1. Honorable Tablanche, do you have any corrections? Shembeni, Sheikh Imam, any additions? The observations, we are now on page 2. The observations of the committee, we're going to page 3. We have captured it very, very much detail. Honorable colleagues, that takes us to the end of the report. Corrections you would like to make to the report? Any corrections? Additions? Do I have a proposal for the adoption of the report?
Chairperson, can I just say something, please?
Yes, Honorable Tablanche, before you reserve your rights, you may
No,
say
that's exactly what I wanted to say. Thank you, Chairperson.
all right. Other political parties, do you like to reserve your rights? Honorable Shembeni? Honorable Shembeni?
Yes, Chair, I was trying. It's only that I'm having a problem with my... Yeah, I reserve my rights, Honorable Chair.
Thank you very much. Honorable Meshu, do you reserve your rights?
Yes, Chairperson.
Thank you. Honorable Sheikh Imam, do you reserve your rights? Honorable Sheikh Imam?
Yes, thank you, Chair. Yes.
Thank you. Do we have any other political parties? I think Dr. Groenewald is not here today. He apologized. Honorable members, do we then have a proposal for the adoption of the report?
Malekwa move for the adoption of the minutes, Chairperson. Thank you.
Molekwa moves for the adoption of the report. Do we have a seconder? Do I have a
Peacock
second?
seconds. Peacock seconds, Chair.
Honorable Peacock? Yes. That takes us to the adoption of the report with those political parties who reserved their rights. Honorable members, we will now do the presentation by the ICRC. The ICRC did not have the opportunity to address the committee because they could not join us last week. We will give the ICRC an opportunity to address us now. Have they sent their presentation?
Good morning, Honourable Chair. This is Sarah Mabeza from the International Committee of the Red Cross. May I answer your question about the presentation?
Yes, you may.
Thank you, Honourable Chair. We did not prepare a PowerPoint presentation for this week as our latest submission, which was circulated yesterday, is quite brief. So instead, I thought I could just make some brief comments and then leave some space for questions from the honourable members, if that's acceptable.
Thank you very much. You may continue.
Okay, just try to turn my video on. There we go. Good morning, Honourable Chair. Good morning, members. Thank you so much for the opportunity for us to speak to you again today. We really do appreciate it. I know that we've been taking numerous opportunities to make oral and written submissions, and I think that speaks to the importance of this issue for us. We really do believe it is a crucial issue, and so we really are grateful for the opportunity to address you again today. As mentioned, I will keep my remarks very brief. I know that the committee has time constraints today, and perhaps rather leave some time for discussion if there's any questions from the honourable members. I hope that everybody was able to receive the latest written submission that we submitted and that Ms. Babalwa circulated yesterday. Thank you very much to her. It's a brief one. It's less than 2 pages, and we just went straight to the issues that we think are of the most concern to the members. If I may just summarize very briefly what was contained in that written submission, and I'm just going to go to the issues that I think are of greatest concern. So firstly, on the proposed deletion of section 1.4 of the existing act, which is what we refer to as the IHL saving clause, I understand that a large reason for the concern from the committee is due to the fact that the FATF recommendations, so the recommendations from the Financial Action Task Force, require or agree with the deletion of section 1.4. And in this regard, I just need to point out from the ICRC's perspective that the FATF recommendations are not binding, and they are what is referred to as soft law, as guidance, whereas the provisions of international humanitarian law, which would be protected by an IHL saving clause, are indeed binding, legally binding on the state of South Africa. Not only is it IHL that is binding, but also the obligations under the 1999 Convention for the suppression of the financing of terrorism, which South Africa is a state party to. And we believe that the interpretation of that 1999 Convention would align with the retention of an IHL saving clause. In this regard, I must respectfully submit that the ICRC does not agree with the FATF's interpretation of international humanitarian law or their interpretation of the 1999 Convention on the suppression of the financing of terrorism. We think that it is an incorrect interpretation, which has resulted in this state of confusion, where the FATF is recommending the deletion of section 1.4 of the existing act. Indeed, what we think is happening is that the FATF is arguing that excluding certain actions from the scope of counterterrorism legislation is what is done by section 1.4, and that is a mistake. However, we disagree with this observation. We believe that incorporating the savings clause in counterterrorism legislation completely aligns with the requirements of the 1999 Convention. And in the written submission, I have set out some justification for that position. Perhaps on that point, I just want to mention that the ICRC is noticing a trend where in a number of states at the moment, the FATF is making this recommendation to delete or to not include an IHL saving clause. And this is of great concern to the ICRC. And so we are launching discussions with the FATF headquarters in Paris very soon to bilaterally have that discussion with them about this recommendation that they are making that we believe is incorrect. So I just did want to also share that bigger picture. Perhaps a last point on the IHL saving clause is just to share an example which will hopefully make what I'm saying a bit more tangible for us. So I just wanted to highlight that incorporating an IHL saving clause in counterterrorism legislation will not prevent the state, will not prevent South Africa from prosecuting the offence of financing terrorism. While it will slightly narrow the scope of activities that are included in the offence, it does not prevent prosecution of the offence in many instances. So for example, where there is an alleged offence of channeling funds to non-state armed groups for the purpose of committing acts of terrorism against the civilian population, that offence would not be protected by the IHL saving clause, and indeed prosecution could go ahead. So although the scope would be narrowed slightly, it's certainly not taking off the table prosecution of a number of offences related to financing of terrorism. Honourable Chair, if you agree, I'll just then share one or two quick points on the second clause that is of concern for the ICRC, which is the inclusion of a humanitarian exemption clause. Again, just a few highlights to note. I think that there's some concern from the members of the committee, which is completely understandable, that in including humanitarian exemption, we are opening the door to terrorist entities impersonating humanitarian organizations. And as mentioned, that's a completely understandable concern. However, as the ICRC, we do not believe that that is enough of a concern to justify the exclusion of a humanitarian exemption.
My apologies, madam. We received your input in writing. Could you be brief, please?
Sure, I'll end off now, Honourable Chair. So just to say, I wanted to comfort the members of, or reassure the members of the committee that
Recording stopped.
Humanitarian exemption clause is not a blank check in any way. There are a number of ways in which it can be narrowed. We made a suggestion of one of the ways to narrow it, but there are a number of ways. And my main message is to say, let's not throw the baby out with the bathwater. There might be concern that an exemption can be abused, but that's not a strong enough reason to not have an exemption. Let's rather look at how we can craft the exemption to make sure that it's valuable and useful. In the written submission, there are a few examples of how we could very clearly make sure that humanitarian organizations that are not exclusively humanitarian in nature do not benefit from the humanitarian exemption. Thank you, Honourable Chair. I'll leave it there, and I'm happy to discuss if there's any concerns or questions from the honourable members.
Thank you very much, honourable members. Honourable members, we received the response of the Civilian Secretariat to the written submission. The Civilian Secretariat has sent us those.
Recording in progress.
I'm sure you have received the responses and you have read it. The issue will be further deliberated in committee. We will go in committee during the clause-by-clause deliberations. We will take note of the concerns of the members now, and it will be highlighted in further deliberations. The matter of the Red Cross will be highlighted in further deliberations. Do you have any further comments on this, honourable members? You received the responses yesterday. Honourable Tablanche.
Chairperson, thank you. I want to thank the presenter for input. It's always good to have, the views from all possible angles. And I think you rightfully indicated that we will deliberate on that further. And we will also, obviously consult, and we have done it already, the state law advisors to come up with, a proper, well-suited, sorted position. Thank you, Chairperson.
Thank you, Honourable Tablanche. Do we have any further comments from the committee members? Thank you, honourable members. I would sincerely like to thank the Red Cross for all their inputs and for their consistent participation in our work. The Red Cross was given time, and they have been really doing stunning work and making very valuable comments. We will not ignore the comments that they have made. They have certainly made us aware of certain very important national and international perspectives. We would have been less informed if they did not do their presentations. So I would really and sincerely like us to note in our report that we commend the inputs of the Red Cross and their participation. Thank you very much, honourable members, and thank you very much to the presentation of the Red Cross. As I said, we'll deliberate further about it in committee. Thank you very much. We will then as well keep you informed, and this will not be the last engagement that we have with you. So our inputs from our stakeholders are very important, and we certainly do have a consultative approach. And the committee tries to, at the end of any amendment bill or any report, we try to have as much consensus as possible. Honorable members, I'm now going to ask our content advisor, Nicolette, to take us through a clause by clause analysis or input on the bill. The committee would then be allowed to listen to Nicolette. She has done this for us before, and we'll then have an opportunity to respond or give our inputs or ask questions. And the civilian secretariat would be with us to engage and assist us with the discussion. Honorable members, you agree that Nicolette does the presentation now? Agreed?
Yes, Chairperson.
Agreed. Honorable members, I'm sure you all agree with me that we do benefit tremendously from the inputs of Nicolette. Nicolette, thank you very much for your hard and professional work, which is normally very objective and professional. You may continue, Nicolette.
Good morning, Chairperson and honorable members. Chair, just to start off, I would like to just say that between myself and the Civilian Secretariat, we thought it best to contextualize the clauses of the bill within the Principal Act to give members more bird's eye view of what or how the clauses and proposed amendments will play into the Principal Act. Chair, I'm going to go through the documents which I circulated, and I will be very brief because we are pressed for time. Chair, just as an introduction, the Poktatara Bill deals with deficiencies by two international organizations, namely the United Nations Counterterrorism Executive Directorate, which highlighted these concerns in terms of the disparity between sentencing regimes, a lack of reference to administrative sanctions, and the clarification of the applicability of the obligation to extradite or prosecute principle in our domestic legislation. Chair, and secondly, the Poktatara Bill deals with two recommendations made by the Financial Action Task Force in terms of the mutual evaluation conducted in 2019 on our anti-money laundering and combating of financing of terrorism system. The report was published in October 2021. Apologies, Tree. And since then, the National Treasury and various departments have been very busy with drafting legislation that will adhere to both these United Nations and the Financial Action Task Force recommendations. Chair, so I noted here the Poktatara Bill deals with two separate compliance deficiencies related to counterterrorism as identified by the United Nations and the Financial Action Task Force. Just quickly to highlight the parliamentary process. Chair, the bill was referred to the committee on the 19th of July. And that may seem a bit long ago, but we must remember that Parliament was in recess from the 20th of June to mid-August, which was quite a lengthy recess, and thus we are only dealing with it now. Chair, I also want to highlight that within parliamentary prescripts, the bill was published in newspapers for a week in all languages, and then the public was given another week for submissions. Chair, but I think the committee did agree in principle that we will extend the public submissions process for a further 2 weeks, and that will currently or presumably end on the 18th of October, as we are planning it currently. Honourable Chair and members, I've just put in a brief background of the Financial Action Task Force evaluation and the grey listing notice that was given to South Africa. Now, in the mutual evaluation report, South Africa rated poorly, and we failed in 20 of the 40 recommendations in terms of technical compliance, and failed in all 11 effectiveness measures. And if members can remember, the representative from National Treasury and from the FIC indicated that these 11 effectiveness measures will be more difficult to actually address, because that has to show the effectiveness of the implementation of various pieces of legislation. Chair, honourable members, as a result, South Africa faces grey listing by the Financial Action Task Force at its February 2023 plenary. To address these 20 technical compliance deficiencies, 11 of these recommendations will be dealt with by bills before the Select Committee on Finance, and 4 will be dealt with by regulatory policy and regulations, and then 2 are dealt with by the current Boktatara bill before the committee. And these 2 deficiencies mainly relate to terrorist financing, sanctions related to terrorism and terrorism financing, freezing orders, and the publication of notices by the UN Security Council. During a briefing by National Treasury to the Standing Committee on Finance, they indicated that the hope is that all these legislation can be
Recording stopped.
Can be passed towards the end of this year in December, and that by early January next year we can have these provisions implemented so as to report to the Financial Action Task Force. Then, Chairperson, in the previous meeting on the 14th of September, I think it was Honourable Whitfield that asked whether all the amendments were necessary to comply and to avoid grey listing, and where the most critical aspect could not be separated and dealt with separately.
Recording in progress.
In response, the FIC stated that all the amendments proposed in the Boktatara bill relates either to the UN anti-terrorism recommendations on deficiencies, and the other by the mutual evaluation report. Chairperson, honourable members, this takes us to the actual bill. Just want to highlight the explanatory note here indicates that the words typed in bold font in square brackets means that the existing enactments will be deleted or proposed to be deleted, and the words underlined with a solid line and highlighted in grey indicates insertions in the existing enactment. Chair, I'm not going to go through the preamble of the Principal Boktatara Act, but I'm just going to highlight the changes made to the preamble of the Pocatara Bill. And the preamble is only changed by the inclusion of various international instruments, as highlighted by the UN, and to which South Africa is signatory or party to. So these are already included. And then these are the ones that must be included into the preamble of the bill. It's the same with these. And just a few of them will be removed, or is proposed to be removed, that is no longer applicable. Chair, honourable members, there's a long list of international instruments that we have become party to since the enactment of the Principal Act in 2004. Getting to clause 1, dealing with the definitions and interpretations in section 1 of the Principal Act. Clause 1 introduces 21 new definitions, which is related to 10 pieces of legislation, including the SAPS Act. Chair, I must mention the SAPS Act was in the, or is in the Principal Act, but it has now been defined separately as the norm is in drafting legislation currently. The new definitions are mostly related to the Cybercrimes Act and the Critical Infrastructure Protection Act of 2019. And the clause further amends existing definitions to comply with international norms and standards. Chair, honourable members, I am not going to read out all the included definitions, but I have highlighted it, such as access is now defined in terms of the Cybercrimes Act, similar with computer data storage medium, and computer systems, all related to the Cybercrimes Act. Then we also have just an amendment here, or an update to the Civil Aviation Act. We've included the Criminal Procedures Act as a separate definition. We then have the critical infrastructure complex and infrastructure, or critical infrastructure, and the specific reference to the Critical Infrastructure Protection Act. Also important, it has been included the directorate, which means the DPCI, or OPS as it's commonly known. And then relating to the electronic communications service provider, we have received a written submission from the Banking Association of South Africa, in which they sought clarity with the section 1 sub E is limited to independent service providers. And in response, the department indicated that it is basically addressed by the ECA in terms of people who is deemed to be licensed, in terms of any other law provided an electronic communications service. And we move on to the definition of an entity, which is in the current Principal Act, but is amended or proposed to be amended to include that this means notices published by resolution of the UN Security Council, and this is in line with the deletion of sections 25 and 26 of the Principal Act, in that the Minister of Finance will now publish the notices or resolutions in terms of entities regarded as terrorist organizations or terrorists, in terms of the deletion, like I said, of section 25 and 26. Chairperson, we have received a public submission by the Banking Association of South Africa, requesting that the term entity must be clarified. And in response, which we're not going to go through, Jay, the relevant clauses in the bill will be amended to align to the two pieces of legislation as indicated by the Banking Association. Honourable members, the definition for explosives or an explosive has been amended to bring it into line with the current international law and norms, including pyrotechnic substances and the like. In the Financial Intelligence Center Act was included, and the information infrastructure as highlighted or defined through the Cybercrimes Act of 2020. Chair, so we can note that there's really substantive definition changes, but all of them are just in line with recent developments in our domestic and international legislation. And also in this one, the Boktatara bill includes 8 new protocols and conventions to the already contained 9 and 13 in the Principal Act. So, Chair and members, we just have the definitions still going on here. The Non-Proliferation of Weapons of Mass Destruction Act has also been included and separately defined, as well as the Nuclear Energy Act. Chair, honourable members, in terms of the amendment to the property, or what is defined as property, we also had a public submission from both the AfriForum and the Banking Association of South Africa. And the main concern here was cryptocurrency that is included. And here, the department indicated that the definition will be amended to also include a crypto asset as a new definition into the Boktatara bill. We then have the Regulation of Interception of Communication and Provision of Communicated Related Information Act. And software and hardware tools as defined also in the Cybercrimes Act, and then the SAPS Act. Like I mentioned, it is in the Principal Act, but it's just separately defined in the bill. Another significant change to the definitions was that of terrorist activity. And the current definition of terrorist activity is in line with the recommendations made by the Financial Action Task Force to include, amongst others, micro or biological agents and weapons of mass destruction, actions to overthrow the government of the Republic or any other government, and then the destruction of substantial damage or interference to information infrastructure or any part thereof. Included here is damage to critical infrastructure or critical infrastructure complex or essential services. Like members can notice, in the Principal Act, there is provision for emergency services, but what has now happened is that it's just clarified that in terms of the Labour Relations Act of 1995, we now include that it is essential services and not just essential emergency services, because there is a distinction to be made between them. Then, Chair, there's quite a number of offences listed, and it's all related to the Cybercrimes Act, like unlawful access and interception of data, interference with data, unlawful acquisition or possession, provision, receipt, or use of a password, access code, or similar data or device in terms of Section 7 of the Cybercrimes Act. And Chair, here, subsection C was wholly proposed to be excluded from the amendment bill because this is very thoroughly captured. Chair, as I mentioned, the amendments to the definition of terrorist activities is in line with the recommendation of the Financial Action Task Force. We had a submission from AfriForum that this is for them a large concern. However, the department indicated that, like they say, granted there is no global accepted definition of terrorism, but the South African Legal Review Committee has recommended that we include the definition of terrorist activity as opposed to a definition of terrorism. And the Sussex Terrorism and Extremism Network, STERN, as presented by Dr. Skuman, proposed the removal of motive, and the department indicated that the motive issue has already been removed from the provisions made in the Bukhtara bill. This then brings us to the deletion of Section 1 sub 4, which is relating to the humanitarian exemption clause. This has attracted much discussion with the International Committee of the Red Cross, as we heard today. Chair, there's been a lot of engagement between the committee, the secretariat, and the ICRC. Chair, I'm not going to go through the lengthy explanations by the secretariat, but the committee will have to deliberate more on this, as Chairperson noted, in committee, whether or not to include this or maybe amend it. But the secretariat, in their written response received yesterday, they have provided a list of examples where organizations have abused their powers in terms of a humanitarian savings clause. I think they gave about 4 or 5 submissions, as highlighted by the Financial Action Task Force. And Chair, honorable members, I've just highlighted here that the deletion was a specific recommendation by the Mutual Evaluation Report of the Financial Action Task Force, but like the representative from the Red Cross indicated earlier,
Recording stopped.
It is not binding to states, and that they will engage with the FAFT in Paris later, and we would be very interested in the outcome of that discussion if the Red Cross could maybe provide us with that. Chair and members, just the Secretariat is very firm on the stance that the deletion of Section
Recording in progress.
should be retained in the Bukhtara bill. This brings us to the end of the first clause, which is quite comprehensive. Now, clause 2 deals specifically with offences associated or connected with terrorist activities, and it includes specifically provisions to address foreign terrorist fighters from the, to include not only the entering through a country, but also departing from or transiting through a country. And the clause further seeks to provide that is an offence to support an entity engaged in terrorist activity. Now, Chair, honourable members, support includes the provisioning of hardware and software tools. Previously, the Principal Act only includes weapons, or the provision of weapons. Support also refers to the joining of a terrorist entity or forcing someone to join. And then also the Pakatara Bill includes that the receiving of training are also an offence. The Stern made a submission on this clause that not only receiving training should be an offence, but also the actual providing of training should be criminalised. And this was accepted by the department as a positive proposal, and they indicated that they will in fact include this into the Pakatara Bill to include online training and not only the receipt of training. Chair, as I mentioned, clause 3 with the insertion of section 3A, which provides for the prohibition of any publication with terrorist-related content. We had two public submissions by AfriForum and the Banking Association of South Africa, and that related mainly to the defence for publishing related content. Chair, I'm not going to read through this whole section, but it is quite important for members to take note as it provides quite an extensive discussion on the publication of unwanted or unlawful terrorist-related content. It is important to note that the proposed inclusion of sub 5 was given as a response by the Secretariat because this contains the defence clause in which members accused of publishing terrorist-related content can arise as a defence, specifically carrying out work as a journalist or for academic research. The submission made by AfriForum specifically related to the violations or possible violation, among other rights, to the right of freedom of expression. And Chair, this the Banking Association submission was a bit different, but in terms of their submission, the department indicated that the comments are accepted. However, there is not a necessity to amend the defence clause, as I mentioned above, as the defence applicable in the clause find application to the entire section 3A as proposed to be inserted in the Principal Act, and includes section 3A sub 2 sub D. Chairperson, honourable members, moving to clause 4, which amends chapter 2, relating to convention offences. This specifically addresses the financing of terrorist activities, and this and also includes the resolutions by the UN Security Council to be published by the Minister of Finance. Chair and honourable members, it also relates to the deletion or proposed deletion of section 25 and 26 of the Principal Act. And this section or clause also addresses the specific recommendations by the Financial Action Task Force through the mutual evaluation report to avoid grey listing. So, honourable Chair and honourable members, for sub 1I includes now to the solicitation or facilitation in terms of property for terrorist activity. Chairperson, it also here includes for the benefit of, or on behalf of, or at the direction of, or under the control of a specific entity identified in an order made under section 23 of the Buktatara Bill. And here it relates to the resolution of the United Nations Security Council, and that it will be announced by the Minister of Finance. Chairperson, honourable members, this inclusion also relates to the proposed changes in terms of the publication of resolutions by the United Nations Security Council. In terms of clause 5, it seeks to amend a new section 4A in the Principal Act in order to provide for an offence in respect of an attempt to leave the Republic of South Africa for the benefit of or at the direction of or in association with a terrorist group. This, honourable members, also addresses the recommendation made by the Financial Action Task Force. We had a public submission by AfriForum that it violates freedom of movement. However, this submission was not supported by the department, as the proposed insertion is to provide legal certainty that South African law criminalizes situations where person abuse freedom of movement and utilize South Africa, a South African territory, as a springboard to join foreign terrorist organizations. And this also latches on then to the addressing of foreign terrorist fighters. Moving on to clause 6. Clause 6 seeks to amend section 5 of the Principal Act in terms of offences related to explosives and other legal devices by extending the offence related to terrorist bombing from only public spaces to also include private spaces. And Chair, this is the only amendment proposed here to include the bombing of private as well, public as well as private facilities or property. Then clause 7 proposes to amend section 6 of the Principal Act related to offences of hijacking, destroying, or endangering safety of a fixed platform by inserting
Recording
additional
stopped.
offences in accordance with international law. It should be noted that similar clauses on additional offences below relates to the hijacking of aircrafts and ships. And just for clarity, honourable members, a fixed platform is defined as anything permanently fixed to the seabed other than a ship, like an artificial island or platforms for oil exploration, things like that. Chair, honourable members, this one is just deleted because it's in line with the manner in which legislation is drafted currently. So here we have the new offences in terms of fixed platforms. Clause 8 only proposes to amend the heading to section 7 to also exclude or delete this, the A, referring only to offence relating to taking hostage and not a hostage, in line with legislative drafting practices. Section 8 of the Principal Act is not proposed to be amended. And as I mentioned earlier, Chair and honourable members,
Recording in progress.
Clause 9 proposes the amendment of Section 9 of the Principal Act in terms of offences relating to the hijacking of an aircraft, and proposes insertion that expands on the method or circumstances under which an aircraft can be hijacked by any other means other than force or intimidation. Honourable members, the bill does not expand on what is meant by any other means to hijack an aircraft other than force or the threat of force or intimidation. And members might want to seek a bit of clarity on what is meant by any other means. Maybe for the department to give an example of other means by which an aircraft can be hijacked. So here that piece is inserted into the Principal Act or proposed. Moving to clause 4, this is very similar to the above clauses in terms of the hijacking of a ship or endangering safety of maritime navigation by providing for additional offences in accordance with the Convention of the Suppression of Unlawful Acts against the Safety of Maritime Navigation of 1988, as amended by the Protocol to the Convention of the Suppression of Unlawful Acts against Safety and Maritime Navigation that was amended in 2005. So this mainly relates to the transport of radioactive material and the like for transporting on a boat or a ship, including explosives or radioactive material or weapons of mass destruction, as defined in Section 1 of the Non-Proliferation of Weapons of Mass Destruction Act. Chairperson and honourable members, it further states that, or basically exams, in terms of sub 4, it states that Section 13 of the Non-Proliferation of Weapons of Mass Destruction does not apply to this, and that Act provides that exemptions can be given by the Minister in terms of the transporting of these materials. Honourable Chair and Honourable Members, moving to Part 3 of Chapter 2, relating to other offences, Clause 11 proposes to amend Section 11 of the Principal Act by substituting the reference to a specified offence with the offence of terrorism related to Section 2, an offence associated or connected with the terrorist activities referred to in Section 3, and any convention offence or offence referred to in Section 13 of 14. Now, this proposed amendment is consistent with the amendment proposed in Section 13 to Section 15 of the Principal Act in terms of clauses 14 to 16 that we highlighted below. So here's that amendment to include offences in Section 2 and 3 of the bill. And then Clause 12 proposes amendment of Section 12 of the Principal Act in terms of the duty to report presence of person suspected of intending to commit or having committed an offence, and failure to so report by providing that no duty of secrecy or confidentiality or any other restriction on the disclosure of information, whether imposed by legislation or arising from common law or agreement, affects compliance by an accountable institution, supervisory body, reporting institution as defined in the Criminal Intelligence Centre Act, or any other person. So, Chair, honourable members, here we have the specific clause that is solicited public comment by the Banking Association of South Africa. In that Section 12, sub 9, creates a hierarchy of legal obligations. However, the department disagreed with this assertion and does not support this comment because the proposed Section 12 sub 9 is derived from similar provisions in Section 37 sub 1 of the Financial Intelligence Centre Act of 2001, and there's no reason why reporting duty and exclusion of privilege in the protection of Constitution on the Pocatara Act should differ from that of the Financial Intelligence Centre Act. Then, Chair, honourable members, Clause 13 deals or seeks to amend Section 13 of the Principal Act in terms of offences relating to hoaxes by providing that the use of false threats to intimidate the public or to divert police resources in order to enable the commission of a crime is an offence. This part of Section 13(1) sub A of the Principal Act is supposed to be deleted to make it clearer that it relates to a very specific offence under Section 2 and 3 and Sections 5 to 10 will be committed and it's deemed as an offence. This also deals with the criminalisation of providing false information and also the diversion of police resources as a result of a crime committed under paragraph C in terms of false information hoaxes, and it states that the offender is liable for any costs proven by the state in that regard. And then it just provides penalty that can be provided if such an offence leads to a conviction. Chairperson, honourable members, Section 14 of the Principal Act is not proposed to be amended, and it deals with threat, attempt, conspiracy, and inducing another person to commit an offence. In terms of Chapter 3, of the Principal Act, Part 1, provisioning related to offences, Clause 14 seeks to simplify the language of Section 15 of the Principal Act in terms of the jurisdiction in respect of offences. And this follows directly from the Constitutional Court judgment of State versus Oka. That has been explained extensively by the Civilian Secretariat, and it amplifies the jurisdictional issues of the Principal Act, as well as where a warrant in respect of offences in terms of the Principal Act may be obtained under our Criminal Procedure Act of 1977. It further provides that persons who are not citizens of the Republic, who are not ordinary residents of the Republic, or persons who are stateless must be advised of their rights to consular assistance from the state where they ordinarily a resident. Honourable members, the clause is in terms of international obligation, provides that relevant governments must be informed of the arrest of a person for a convention offence. The clause specifically highlights and includes that the Directorate, and in this sense, the Directorate means the DPCI or WOX, may initiate an investigation, or the National Director may institute a prosecution in respect of, and then remove any specific offence as determined in paragraph A for the definition of specified offence, to rather state that the offence of terrorism, which is more specific, referred to in section 2 and 3, and referred to in section 13 or 14, will be included in this section of the Act. Then, Chair, honourable members, this part of the Principal Act was not proposed to be amended, as sufficiently provides for the arrest or investigation of foreigners. Subsection 2A, or the inclusion of subsection 2A, refers to any person referred to in subsection 2 that may be arrested to appear in court pending a determination of the issue of extradition. And if members can remember, right at the beginning, I indicated that the UN Anti-Terrorism Directorate referred specifically to clarification or more detail on South Africa's principle, or the principle to extradite suspected offenders. And this section deals with any offences committed in a country outside of the Republic, through subsections C, D, and E. And subsection 3A includes procedures where it's not possible to obtain a warrant of arrest for an accused on grounds provided for in section 43 sub 1 sub B of the Criminal Procedures Act, a magistrate or a district of the police registered the complaints may issue a warrant. G, this section mainly remains unchanged by the provisions of the Bakhtara Bill. Then we have the inclusion to include when a person who is not a citizen, as mentioned above, not a resident or stateless person, are provided for to be receiving counsel, and that the government or governments with established jurisdiction must immediately be notified through the diplomatic channel of the arrest of such person. It just subsection 11 provides for the National Commissioner or National Head of the Directorate in terms of the DPCI may consider to inform any other interested government about a person in custody and the circumstances which warrants that person's arrest. And then to further highlight the rights, a person referred to in subsection 10 must as soon as possible upon arrest be informed of his or her rights to request that the relevant government be informed of such arrest, have access to communicate with the consular representative of the relevant government, and expect that any communication addressed to the relevant consular post about the arrest of such person is forwarded to the relevant authorities without any delay. Honourable members, moving to clause 15 of the Bakhtara Bill, it seeks to amend section 16 of the Principal Act in terms of consent of National Director to institute proceedings and reporting obligation, and provides that the prosecution for an offence under section 13 may be instituted without the written authority of the National Director and may be authorized by the relevant Director of Public Prosecutions. In terms of section 16 sub 1, it is then included that this can be instituted except in the case of a prosecution under section 13, which is not linked to any other offence under this Act. And honourable members, section 13 deals with hoaxes and the basic essential wasting of police resources. Moving on to clause 16, it proposed the substitution in section 17 of the Principal Act relating to evidential matters and exclusion for the reference to the Department of Foreign Affairs with department responsible for international relations. Honourable members, the only why this was changed is that in 2009, the Department of Foreign Affairs was renamed to the Department of International Relations and Cooperation, as indicated here in sub 1. No further amendments is proposed to this part of the section 17 of the Principal Act. And it brings us to chapter 3 of the Principal Act in terms of provisions related to offences and penalties, part 2, penalties and matters relating to penalties. Now, clause 13 aligns the sentencing as laid down in section 18 of the Principal Act with the severity of offences especially in relation to the financing of terrorism. That was highlighted by the Financial Action Task Force, as well as the UN Anti-Terrorism Directorate. It basically lengthened the imprisonment of various courts, including the High Court, Magistrates Court, or Regional Court. Honourable members, in terms of this, we have received a public submission from AfriForum, in which they express their concern with the excessive sentencing under this section. However, the submission was not supported by the department on account that it is related or very much aligned with international sentencing regimes. For instance, a High Court imprisonment or regional court is increased from 15 years to 30 years. The fine is not amended. And then also, yeah, in the case being passed by High Court, also regional court, the imprisonment period is increased from 10 years to 15 years. Similarly, in subsection E, where the imprisonment is quite significantly increased from 5 years to 15 years. And then it highlights that in terms of section 24B, the new inclusion, sub 12 or sub 13 is liable to a fine or imprisonment not exceeding 1 year or both such fine and imprisonment. In terms of this, it's very important to read it with the with those sections as proposed in the Bukatara bill. As I mentioned, AfriForum raised concern with this issue. And they also raised concern with the inclusion of what is meant by reasonably be regarded as it introduces a form of negligence and sufficient intention of knowledge of wrongdoing for purposes of criminal liability, and is likely to lead to complex legislation. However, the department stated that reasonable grounds to believe within the context of this section does not relate to criminal liability and therefore does not establish intention of knowing of wrongdoing. Instead, it sets an evidentiary standard that the state must meet to obtain a freezing order, which is also quite extensively dealt with later in the Bukatara bill. The evidentiary standard is applied by a judge when the National Director of Public Prosecutions bring an application for a freezing order. The power is not exercised by a police official. Chairperson, honourable members, during the deliberations, members did raise quite extensive concern about the overextension and the possible abuse of state power, especially in terms of emergency or disaster, as was seen during the COVID-19 lockdown. In terms of Section 19 of the Principal Act, Declaration of Forfeiture on Conviction, the Bukatara bill does not propose any amendments. Apologies. And then similarly in Section 20 of the Principal Act, interest of third parties, no amendments are proposed to the section by the Bukatara bill. Honourable members, moving to section 21, evidence in respect of declaration of forfeiture and certain interest. Also no amendments are proposed. And that is similar to section 22 in chapter 4 regarding the investigating powers and placing orders. Specifically in section 22, there are no amendments proposed. However, honourable members, clause 18 proposes a substitute section 23 of the Principal Act as a consequence of the proposed repeal of section 25 relating to the publication and parliamentary supervision, and expands on the ambit of and what may be contained in a freezing order, the making of ancillary orders, the publication of orders, the appointment of a curator ad litem, and interim orders. And all of these are related, especially in terms of freezing orders, amended by the recommendations made by the Financial Action Task Force. It is quite an extensive substitution and very detailed. The previous section regarding the High Court's issuing of freezing orders is completely removed and substituted by a new section, as I mentioned, relating to the issuing of freezing orders in relation to terrorist or suspected terrorist activities. Honourable members and Honourable Chair, I'm not going to read through the entire section because it's quite lengthy, but it is very comprehensive in terms of the power of the High Court, but also includes protections as to not abuse this issuing of freezing orders. I think it is very important for members to go through that prior to our further deliberations in the next term. Then getting to clause 19, it proposes to amend section 14 of the Principal Act in terms of cordoning off, stop and search of vehicles and persons by simply providing the inclusion of premises, and now contains a cordoning off, stop, search of vehicle, person and premises, and just expands that power to also premises and not only a person or a vehicle. It also provides strict provisions for when a warrant can be obtained to do this. And then Chairperson and members, getting to clause 19, it proposes the insertion of section 24A into the Principal Act, which provides for the application for the decryption direction by an official officer of the Directorate, meaning the DPCI, in terms of section 21 of the Regulation of Interception of Communication and Provision of Communication-Related Information Act. The inclusion of section 24A proposes quite extensive changes, and we have received a public submission from AfriForum in arguing that this inclusion violates the RICA and also violates the right to privacy of citizens. The clause further provides the insertion of section 24B into the Principal Act, which provides that a member of the Directorate, meaning the DPCI, may apply for a competent court for an order to disable access to internet or social media sites with unlawful terrorism-related content. This is the issue that was raised also during public submissions in terms of decryption key, in which it was argued that decryption assistance must also be provided. And then this proposed inclusion of section 24B goes into much detail on how the DPCI may apply for High Court to issue an order to remove access to publications on internet or social media sites with unlawful terrorism-related content. It provides also for, it specifies the process. It also provides some safeguards in terms of not abusing this power. As members can see, it's quite a lengthy inclusion, but very important for members to also work through in terms of the provisions of powers of the person and the electronic communication service provider, that, for instance, may apply for relevant court for the setting aside or amendment the order as provided above within 30 calendar days. In terms of the public submissions and responses by the Civilian Secretariat, they indicated that Section 24A will be revisited to specifically deal with decryption assistance and passwords or other access technology restrictions on electronic communication devices, and reference will be made to the United Kingdom law, UK Terrorism Act of 2006. Chairperson, honourable members, moving to Chapter 5, resolutions of the United Nations Security Council through Clause 21. It is proposed that Sections 25 and 26 of the Principal Act in respect of parliamentary supervision is removed. It proposes that the publication of resolutions by the UN Security Council relating to sanctions imposed on entities linked to terrorism and announced by notice in the Gazette should be performed by the Minister of Finance in terms of the FIC Act and no longer by the President for parliamentary consideration. This is also aligned with the recommendation made by the Financial Action Task Force, and I've included here the sections that are supposed to be removed from the Principal Act. AfriForum contested that the deletion of these sections unjustifiably violates the separation of powers, and that Section 26A of the FIC Act makes no provision for the tabling of announcements in Parliament for consideration. However, honourable members and Chairperson, it must be remembered for practical purposes, Parliament cannot reject or amend a resolution of listing by the UN Security Council. The implementation of these designations following the adoption of a resolution by the UN Security Council is an executive function. The General Law Anti-Money Laundering and Combating Terrorism Amendment Bill that is currently before the Standing Committee on Finance provides in effect that all notices that relate to the adoption of resolutions by the UN Security Council and subsequent designations and delisting of entities under this resolution will be issued by the director.
Oh,
The-
Nicolette, we lost you for a minute. I don't know if it was just me. You can continue.
Thank you, Chair. Then moving to, I'm almost done. Chapter 6 regarding general provisions. Clause 22 proposes amendments to Section 27 of the Principal Act by providing that any proclamation issue under 25(1) that is now proposed to be removed stay valid with the same force and effect as when it was done previously. Clause 22 also seeks to amend the Principal Act to provide that any action taken in pursuance of proclamation under the now proposed deletion of Section 25(1) before the amendment of the Bokutara Bill, when it becomes an act in 2022, will remain valid. Chair, the amendment to Section 25 just basically states the intention of the clause as mentioned. Chair, and as in a nutshell, that is what the Bokutara Bill proposes to change in the Principal Act. I do hope that members have gained a better understanding of the entirety of the Principal Act in terms of the Bokutara Act, and that the amendments proposed by the bill is really alignment to international laws and standards, norms that has been adopted since the or changed since the adoption and enactment of the Bokutara Act in 2004. I thank you, Chair.
Thank you very much, Nicolette. That presentation was very fair, independent, and objective. I certainly think that our work will assist us in improving the lives of not only our citizens but the position of the country globally. I would like to also then request, Nicolette, you can mute your mic. A number of members have indicated that they have connectivity problems. I think that even Babalwa is battling with a connection. The weather is very bad where she is, so we'll just assist Babalwa with the minutes. Honorable members, I think that we just have to note the message of Dr. Khanyasa Twalo that Nicolette, she just has to clarify that the advert on this bill went out on the 5th of August and the closing date was the 19th of August. So we just need to correct the fact that, I'm sorry, Nicolette, when you said the public had a week, they had more than a week to comment, and that was within the prescriptions of what is required of the committee. We'll just correct that. Am I correct, Nicolette?
Yes, Honorable Chair. Apologies that didn't come out completely right, but yes, it was in the week we combined the 2 week and completely in line with parliamentary procedure.
Thank you very much. Honorable members, there you have the presentation. Do you have any questions or comments before I allow the Civilian Secretariat to respond? I could take a list of hands now. Honorable Tablanche.
Chairperson, thank you. Now, I just want to thank Nicolette for a sterling job done. I really think this is very, very helpful. And, Nicolette is always, on top of her game. And really, this, as I said, will assist us quite a lot. So thanks from my side for her effort. Thanks, Chairperson.
Thank you very much. Any further hands? I don't see any further hands. Civilian Secretariat, would you like to comment for today?
Thank you, Chair. Chair, we just want to say thank you to Nicolette for that comprehensive presentation that she just did. It even made me get a better understanding as well, and of all the comments that were made and the responses by ourselves. If there's anything extra that needs to be added, we will do so in writing. Thank you, Chair.
Thank you very much, Advocate. Nicolette, could you just spell out the next steps and the way forward from today?
Thank you, Honourable Chair. The way forward from here is that we have sourced quotations for the further publication of the bill for public comment. Preliminary, or as we have planned, the bill will now run for a period of 3 weeks, thus extending the original 2 weeks. Then 2%, the deadline is on the 18th of October, and thereafter we will then engage again on public participation and deliberations. But Chair, we will share the proposed program with members after the meeting, if that is okay with you. Thank you, Chair. Chairperson?
Yes. Thank you, honorable members. I think that takes us quite a while and quite a way forward. Honorable members, do you have any comment to that? Nicolette, is your hand up again?
Yes, Chair. If I may just quickly clarify, the reason why we are also beginning only towards the end of October is that once members can come back in the 4th term, there's a great urgency to consider the annual reports as part of the BRRR process, and then thereafter the bill will be prioritized. Thank you, Chair.
Thank you very much, Nicolette. Members, Civilian Secretariat, are we all in agreement with this? There's no opposition, so I believe we're all in agreement. That takes care of that item on the agenda. Nicolette, do we have any further items?
Chairperson, I think that concludes the business of today. I think Babalwa Shami is kicked out of the meeting due to connectivity problems. But Chair, I think that is the end of the meeting, concluding business. Thank you, Chair.
Thank you, honorable members. I think we've taken all the comments today. We've gone through the bill in much detail and the amendments which is proposed. I do believe that we could communicate with each other in writing via email. We are really progressing very well on this. You also heard that the Minister of Finance, in his comments in the House last week, indicated that there's a necessity to have this amendment bill passed as soon as possible. As I said initially, we will not rush it, but we certainly realize the urgency of processing this bill. The meeting is now adjourned. Thank you very much. Good luck to those who are speaking in the House. Thank you very much.
Thank you, Chair.
Thank you, Chairperson. Bye.
Josie.
Bye-bye. Bye.